Good morning, this is your Kelso Report for Wednesday, January 9th, and I'm your host, Clark Kelso. The United States Supreme Court gave us two easy decisions yesterday, the first involving the issue of what constitutes a discharge of a pollutant under the Clean Water Act, and the second involving the issue of incompetence of a petitioner in a habeas context. The Ninth Circuit has an interesting decision involving enforcement of an IRS administrative summons for documents held by the taxpayer's criminal defense attorney, and we have a state court decision involving revocation of a dentist's license to practice. Let's get started with the Supreme Court. The Clean Water Act regulates any discharge of a pollutant. In LA Flood Control District versus Natural Resources Defense Council, the Supreme Court granted cert to determine whether a discharge of pollutants occurs when polluted water flows from one portion of a river that is navigable water of the United States through a concrete channel or other engineered improvement in the river and then back into the same river. The issue arose in the context of the stormwater discharge system in Los Angeles. The Ninth Circuit held that the LA Flood Control District, which managed several pollution monitoring facilities, was responsible for discharging pollutants when water flowing through those facilities was discharged back into the river. Under this Ninth Circuit holding, the district could become accountable for all upstream pollutants in the water. Well, the Supreme Court unanimously rejected this conclusion and reversed based on its prior decision in South Florida Water Management District versus Muskogee Tribe, where the court held that pumping polluted water from one part of a water body into another part of the same water body is not a discharge of pollutants under the Clean Water Act. Next, we have a case involving habeas corpus. The competence of the defendant in a criminal proceeding is a constitutional requirement for receiving a fair trial under the Due Process Clause. Because if the defendant is not competent, he or she is unable meaningfully to participate in his or her own defense, and that makes the proceeding fundamentally unfair. In Ryan v. Gonzalez, the Supreme Court considered whether that same rule should apply to a federal habeas proceeding. The Ninth and Sixth Circuits held that district courts must stay federal habeas proceedings when petitioners are judged incompetent. Well, the Supreme Court again unanimously reversed, noting that a habeas proceeding generally involves only a retrospective examination of a paper record, and the petitioner's personal involvement in prosecuting a federal habeas is much less important than his or her participation in the underlying criminal proceeding. Although there are federal statutes that guarantee a right to counsel in habeas proceedings, those statutes say nothing about the competence of the defendant and do not require that proceedings be stayed during a period of incompetence. Next, we have a Ninth Circuit decision involving an IRS administrative summons, something that all of us should listen to pretty carefully. The Fifth Amendment grants persons the privilege not to provide the government with self-incriminatory evidence of a testimonial or communicative nature. Now, this protection extends not only to oral questioning, but does apply to prevent an individual from having to produce documents for investigative bodies, but only if the act of production itself would be testimonial. Now, this protection extends to prevent an individual's attorney from being compelled to produce documents if that production would violate the individual's Fifth Amendment rights. Whether the production of documents is testimonial depends upon whether the mere act of production communicates material information about the existence of the documents entirely apart from the contents of the documents. But where the existence and location of documents are a foregone conclusion based on independent information secured by the government, enforcement of a summons for those documents does not violate the Fifth Amendment. All right, this set of rules played out in United States versus Simon and Bancroft, which involved an IRS criminal investigation into a taxpayer's filings. Through an interview with the taxpayer's tax preparer, the IRS learned a lot of detail about the nature of the tax records which had been given to the tax preparer by the taxpayer. And the tax preparer told the IRS that the records had been turned over to the taxpayer's attorney. So there was enough detail in this information that the government was able to establish the documents' existence, their authenticity, and the law firm's possession and control. And that satisfied the foregone conclusion standard, so the Ninth Circuit affirmed enforcement of the summons. Not surprisingly, it's hard to hide from the taxman. Finally, we have a case involving professional licensing. Government boards with regulatory authority over professionals, often come under criticism for being too lax in the use of their enforcement powers. There is, in fact, a philosophy of progressive discipline that tends to favor incremental steps instead of more aggressive, harsh penalties. But that certainly wasn't the case with the Dental Board of California in Hanna versus Dental Board. In this case, the Second District affirmed the decision of the board to revoke the license of a dentist who had pled no contest to a felony count of Medi-Cal fraud. The dentist tried to argue that revocation was a manifestly excessive penalty and abuse of discretion, but the Second District was having none of it. As the court concluded, quote, "The seriousness of appellant's misconduct, her unwillingness to admit any wrongful acts, and her failure to establish that she had undergone any rehabilitation demonstrated that the public could not be adequately protected unless appellant's license was revoked," close quote. This decision hopefully sends a strong signal to health professionals in all disciplines about the seriousness of defrauding the system. And that's it for today's Kelso Report. Have a great day in the law.